Yeah, so as I was saying, we are dealing with recovery of premises, and as we all know that law school topics are a layer of each other. Say for instance, last week we spoke about enforcement of judgment in between, and there was a point where I gave a difference between warrant of possession and writ of possession, which will of course make sense in this topic as well. As much as we deal with enforcement of judgment, this topic ends to do with one of those enforcements, which is the warrant of possession, right? Which typically comes at the end of when one wants to recover their premises. So just to move straight into it, so we don't waste much of our time, is the recovery of premises. And I think the few things that I think it is necessary that I need to point out, I assume that, and from what I understand, you guys might have not have been taught this topic in law school, or possibly you are yet to read it, so it might be a bit nuanced. But what I will want to state to make it understandable by the point of your reading is just few things. One, when it comes to recovery of premises, it's not that property law, it's in civil litigation, so that you also don't mix it up, because many times there's this ideology that it's property and so it is property law, but this is in civil litigation. One. Secondly, you need to please pay attention to your days, your laws, and your periods. Saying that because for recovery of premises, we have few laws that regulate it. We have the Recovery of Premises Act, that is general, recovery of premises law for states. We then have, for instance, in Lagos State, we have Tenancy Law of Lagos 2011. Now, I'm sure a point in property or somewhere where you've been taught that the applicability of under the applicable laws in property law. So expanding on that, you realize that for recovery of premises or property law generally, we know that there's a law that applies to everywhere, to some parts in Lagos and not everywhere in Lagos. For instance, when it comes to recovery of premises law, we know that recovery of premises law applies to places except for 5 areas in Lagos, which is the Ikoyi, Ikeja GRA, Ikoyi, VI, Apapa, and one other place. There are 5, right? Which means that where the tenancy law of Lagos is not applicable in those areas, you use the recovery of premises law to come in, right? Basically, we know that the recovery of the tenancy law applies to every other places except Ikeja GRA, Victoria Island, Ikoyi, and Apapa, section 1 sub 3 of the tenancy law of Lagos. It means that every other areas outside of these 4 areas or 5, it is the recovery of premises law that applies. It is the tenancy law of Lagos that applies, while in those 5 areas, it is the recovery of premises law that applies. Meaning that, say, when you go on to the point of statutory notices, or when it comes to statutory notice, you need to know what is applicable in those areas, because there are different notices that is applicable in those specific areas of Lagos, right? Of diverse part of the area. But now, just to move and just to be fast, please also note that aside the law, you need to also pay attention. As I pay attention to the law, one need to pay attention to the states. Tenancy of Lagos only applies in Lagos, right? Recovery of Premises Act applies to every other place except Lagos, except the places that Tenancy Law of Lagos applies to. The issue of courts for recovery of premises is based on it's also based on the monetary jurisdiction of the court. Say for instance, the Magistrates Court Law of Lagos 2009 and the High Court Civil Procedure Rules. It means that the same monetary provision that applies to Magistrates Court that says that where the monetary sum is less than 10 million naira, you can bring an issue with it. I'm sure when in this earlier part of civil litigation on jurisdiction of the courts, it has been spelled out. So it means that for issue of rent, where the rent is less than 10 million naira, you can institute the action in magistrate courts. But where it is above 10 million naira, you have to institute it in what? The High Court of that state. It means that, say for instance, you have a problem question and the problem question is telling you that the rent value of the property is 50 million. Typically, it means that you cannot say you want to institute the action in magistrate court. It has to go to the High Court. If you see a rent sum of less than 10 million or less than about 5 million, it means that when they tell you to draft the process, you don't need to draft it at what? High Court of the state. You need to draft it at the magistrate court, because it is still within the rental monetary value of the magistrate's court. Please, if you have questions, please just notify me. This class is meant. We have limited time, so you can just let me know in between. And for the district court, like I mentioned, the court division magistrate court, we all know that the rental value of High Court is Lagos, right? But for Abuja, it used to be less than 5 million, but I think now 7 million. Between 7 million downwards, you can see it at the district court. We know the difference between district court and magistrate court in Abuja. District court is mostly for their civil, while magistrate is for their criminal proceedings. While in Lagos, magistrate is magistrate. Both, there's no difference between magistrate and district. So it means that if you are drafting, if they tell you the area is Abuja and you are saying 5 million naira, as much as you have an idea that it is magistrate court, you don't draft it as in the magistrate court. It is district court. Their civil proceeding section is known as district, while the criminal is known as magistrate. It is still in the same courts, same judge or same magistrate, but for civil purposes is known as district, and for criminal is known as magistrates. Yep. Now, on the other side, you also need to know, for you also to be able to understand your instances of recovery of premises, you also need to understand the types of tenants. I'm saying that because, the general provision, so almost everybody have the idea that everybody is entitled to 6 months notice, or to at least some notices. Maybe it's a 6 months or 3 months or a week or a month, thereabouts. Everybody know that there's some particular notice that everybody is entitled to. However, not everybody is entitled to the general quit notice. Some tenants are just entitled straight to 7 days owner's intention to recover possession, meaning that they are not entitled to the typical notice to quit that we all know or have an idea about, right? Everybody. So this, knowing the types of tenants, knowing when a notice is required and when an owner when what is required is just owner's intention to recover possession, is just it is needed. It is also very important to identify that as well, which is why we're trying to talk about the types of tenants. So we have tenants at will, right? A tenant at will, it only holds possession with the consent of the landlord, but does not have a fixed term of duration, meaning that you are not typically a tenant that says that, oh, you are a yearly tenant, you are a monthly tenant, you are a quarterly tenant. What you just have is somebody telling you have to stay in the house. You have the consent of the landlord to stay in the house for as long as you want. Say for instance, Temitayo has a house, and say for instance I have an housing issue, and she said there's an house, and she's like, oh, okay, please don't worry, I have an empty flat. You can stay there until you get a place, or you're able to get enough money to rent an accommodation for yourself. That is a tenancy at will, because I have the consent of the landlord, of the owner of the house. I only have possession of that same. Now the issue is when my rent, or when she wants me to leave the house, she can't give me any notice, nothing like maybe 6 month notice or 3 month notice. The only thing I'm entitled to is just 7 days owner's intention to recover possession, because what I have is just possession, and what she's requiring for is just for me to just recover, for her to just recover the possession from me, and just I hand it over, and that is it. So it's just like it's so that it not look like unfair and tell me that, oh, the next day please pack out. I'm just going to give you 7 days notice. Oh, please, I need my house by next week, so please, you have this week to figure out whatever you want to do, and that will be it. That's what tenancy at will is about. Now, we have tenancy at sufferance. Tenancy at sufferance basically means that you are a lawful tenant, right? You are a tenant, you entered into occupation, into the premises, you are occupying the premises lawfully. But after the expiration of the tenancy, the tenant continues to hold possession without the consent of the landlord. Now, we know that for tenancy at will, the landlord has consent of you staying in the house, of you holding possession. Tenancy at sufferance is just letting you know that you are a lawful tenant. Your rent has expired. You have not renewed. You've told the landlord you will pack out of the house. The question is this. Let's say for instance, the landlord is, all these some houses that the landlord doesn't stay in the same compound with them. So the landlord cannot know whether or not the person have moved out. So your rent has expired and you're still staying in the house. The landlord doesn't know. You don't have the consent of the landlord to stay at the house. For tenancy at will, you have the tenant has the consent of the landlord to remain on the property. However, for tenancy at sufferance, the person has how will I put it? Without the consent of the landlord. Now, for tenancy at will, we know that the person is just entitled to, the tenant is only entitled to 7 days no owner's intention to recover possession. However, for tenancy at sufferance, because you were once a lawful tenant, a well-paying tenant, however, you have defaulted and you have refused to hand over the property back to the landlord without the consent. Now, it means that the landlord also cannot just enforce the right of re-entry and just eject you, right? Do you get? However, the tenant is still entitled to the general process of eviction by law. That is, the landlord cannot just come and tell you, "Oh, pack out of my house," right? The tenant the person is still known as a statutory tenant because the person was entitled by law and can only be ejected by due process. And what is the due process? You serve a notice. You serve a notice to quit. After a notice to quit, you serve a 7 days owner's intention to recover possession. After that, you then go to court. After the court decision, then you get your warrant of possession. Then that's when you can eject the person out of the house. Right? That's a major difference between tenancy at sufferance and tenancy at will. We have tenancy by estoppel, right? The landlord cannot deny that they don't know you. Estoppel, basically, to stop somebody. So the landlord cannot deny that, "Oh, you're not my tenants. So far, you've been in occupation of the house." The landlord cannot just come and call you a squatter. Say, for instance, we have a matter that we're handling at the moment at my firm, and in between it, we have an issue whereby the person knows the land, the person is rightful owner. However, in between everything, the landlord is trying to claim that the tenant is a squatter. That is to show that, "Oh, I don't know this person. The person is not my tenant. You're a squatter. However, this person is a lawful tenant," and that's what we know as tenancy by estoppel. Now, we have a licensee. A licensee is a person that is permitted to use the premise without having any exclusive possession. You don't own the land. You don't own the property. You don't occupy the property. However, you are using it. You are using the premise for a particular purpose, right? Typically when you are a tenant, you have the right to what they call exclusive possession. You are not to be disturbed and all those stuff, right? But for a licensee, let's say for instance, Temitayo has a property, and say for instance, I'm trying to start a business, and she's my friend, and she says, "Oh, Michael, I have a boys' quarter that I'm not using. It's small, but you can use that to maybe as your warehouse to store whatever you want to store for the time being." Now, it is similar to tenancy at will, but what she's giving me is no exclusive possession. She's just letting me use a part. It's like renting the place limitedly for me, right? It is out of a privilege. She's just permitting me to use it. Or let's not even say maybe the whole flat, maybe a part of the compound, right? That's a licensee. You're just, you're letting me use just a part of the property. Now, a licensee is also similar to a tenancy agreement because they're not entitled to a general notice to quit. It's just also a notice of a 7 days owner's intention to recover possession. We have statutory tenants. Statutory tenants are tenants that, by law, they are backed by tenant. They are backed by law, right? It means that you cannot eject them unless you cannot eject the person from the premises unless there's a full law, is a full legal action against them. You institute an action by following due process because they are statutory tenants, right? Then periodic tenants are more or less similar to statutory tenants because under statutory tenancy there are people whose notice are periodically, maybe weekly, monthly, quarterly. It also follows the form of periodic tenants, same thing with statutory tenants in a very similar way. Then tenancy for a fixed period. Tenancy for a fixed period, let's say, most times tenancy for a fixed period is like a long lease. Most times a long lease because they always terminate by a fluctuation of time. And once that happens, there's no notice to quit. It's just 7 days owner's intention to recover possession. Say for instance, Temitayo is renting an apartment to me for maybe your office space, and we execute a long lease, say 20 years, right? I'm a tenant. It's a limited period of time. Once that 20 years is up, that's all. Or let's say my rent is 2 years. At the end of that 2 years, that is up. And I think I also know that for the purpose of bar finals and MCQ, I know you guys know the difference between what is when you use tenants and when you use tenancy and when you use lease. That is, difference between when to use for purpose of bar final. When the difference between trying to write landlord and lessor, tenants and lessee, using the terminology. We all know the lesser than 3 years, above 3 years gap or rule, right? So that being said, I think that is the purpose that you need to know for recovery of premises. Now, what are the material facts that must be proved for every recovery of possession premises? You must prove that the rent is in arrears, the tenant has committed a breach or has breached an express term of covenant in your agreement, the landlord wants to use the property back, or the premises has been abandoned, or any of those things, you can recover your premise. But most importantly, one thing to note out is that the procedure for recovery of premises is, and you must follow it. It is a standby rule. We have the case of Coco and Adetayo. Now, there's a similar difference between AP and Owodoni and Coco and Adetayo. I prefer to use the eventual or more solid decision of the court is more in Coco and Adetayo. You can use AP and Owodoni. AP and Owodoni is African Petroleum Limited and Owodoni, which speaks more as to time of notice and every other thing. But Coco and Adetayo is a more comprehensive provision, as it starts from the court distilled the issue from letter of instructions down to enforcement and injection. So it covers everything, right? Which starts from you saying that you want to obtain your letter of instruction from a landlord, meaning that the landlord must what. And one very funny thing about notice to quit, a lawyer, it is not compulsory for a lawyer to be the one to issue a notice to quit. It's one of those documents that a landlord can, by its own volition, decide to issue a notice to quit without having to make use of a lawyer. However, whenever I want to make the landlord make use of a lawyer, it is important that that an official letter of instruction is given, not verbal. Say for instance, as much as let's say my parents have a house and there's a tenant and they really just want to eject the tenant notice to quit, and I'm like, oh, you're my son, let me give this tenant notice to quit. For purposes of court processes or court procedures, or typically you can just issue it. It's very easy without having to have a long back and forth. But if you're going to issue it on behalf of your parents, because you are a lawyer, the rule stands that you really have, your parents have to really give you a letter of instruction. That is where the major issue of in Coca and Adetayo started from, there must be an official letter of instruction. Oral instruction is not valid by law, it must be written. So there must be the letter of instruction if you are using a lawyer. If you are not using a lawyer, that's fine. A landlord can go ahead and issue notice to quit without having to have any lawyer written, whatever. But if you are going to use a lawyer, there must be a letter of instructions. Then you must serve the notice to quit. When you serve notice to quit, once it expires and after expiration, the person is yet to leave, you then issue a 7 days owner's intention to recover possession. When that doesn't work, then you then have to go to court, institute a proceeding to recover your possession, then to recover your property. Then that's when the whole trial comes in, judgment. And when you then get the judgment, you are given a warrant of possession. Warrant of possession is one of the major means of enforcing recovery of premises. I think at the last class we spoke about the difference between warrant of possession and writ of possession under enforcement of judgment. So for this, what you'll be given is a warrant of possession. So then you use it to eject the tenant from the property. Right. Now, back to the notice to quit. Notice to quit has duration. And I think I'll lay a bit of emphasis on this because of the issue regarding notice to quit, the timeline, and the laws regarding it. Now, like we've said earlier, we have two basic laws that I think you want to focus on. We have the Tenancy Law of Lagos and we have the Recovery of Premises Act. Now, both laws speaks to recovery of premises. Both laws speaks to the length of notice. However, there is a nuance in both of them regarding expiration of notice. When can your notice expire? And please note, your notice must not be 1 day short. Now, this is where it can be longer. So now let's go back. So I think I will start from notice. Typically, everybody have an ideology that every notice everybody is entitled to 6 months notice to quit or duration of notice to quit, as the case may be. However, a yearly tenant can also be entitled to just 1 month notice as opposed to the 6 month notice that is available by law. Why this is so is on the basis of what? Contract and agreement. The general rule is that what everybody is free, everybody can enter into contract freely, right? And the court always interprets it because there's the assumption that you have sound mind by the time you're entering into your contract. You reviewed it and you agreed to it. So in your length of notice is dependent on your tenancy agreement. That's straightforward, and that's like the easiest thing you should know. And beyond just tenancy, I think in practice generally, whenever, let's even say your mortgage, or whenever there's an issue regarding any dispute or anything regarding, the first thing that they always tell you to consult is go back to the terms of your agreement. Say for instance, there was a time we were working on something that has to do with some mortgages, and there's a bit of nuance regarding the mortgage transaction. And the first point of contact is we really have to go back. Everybody has to be before we know what the law says as to mortgage, you know what the law says as to so many other things. But the first thing you need to go back to is what is the deed of legal mortgage talking about? Did it give rights for this instance? Did it permit this? Same thing for your tenancy agreement. There's typical ideology that is 6 months. But trust me, if you enter a valid tenancy agreement, you have sound mind, and as a yearly tenant, the notice that you agreed with your landlord is 1 month. If you like, go to court tomorrow. What court to uphold is that 1 month notice, because it is the written agreement. So now, where there is no now agreement, or where your agreement or your contract with your landlord is now silent, that is where statutory notices that are applicable in the laws will now come up. Right? It means that if you're a landlord that agrees 1 month, the first point of notice of length of notice goes back to what? Your contract. Whatever is agreed in your contract is the length of notice. However, where the contract is silent on notice period, or maybe there's even no executed tenancy agreement, what you then look at is what the law will look at by operation of law. How well have you been paying your rent? If you've been paying your rent quarterly, the law will then assume that what, you're a quarterly tenant. How well have you been paying your rent? You've been paying your rent half yearly or every 6 months, the law will assume you as a what? As a half yearly tenant, as it is applicable under Lagos State. And if you have been paying your rent yearly, even if there is no agreement, the court will then assume the position of you being a yearly tenant. Now, that is when statutory notices will then kick in. That is where you can then come and say that, oh, the length of notice applicable is 6 months, 3 months, as the case may be. So where the person is a tenancy at will or is a weekly tenant, we all know that there are some places in Lagos and some parts of Nigeria whereby people pay their rents weekly. In those instances, the only thing that they are entitled to is a 7 days notice. That is a week notice because they're a weekly tenant. If they are a monthly tenant, what the persons are like, say for instance, in foreign jurisdictions, say UK, US, some of them, the law, I think not until recently that even the law is trying to then allow for, I think I saw one of the UK bills of trying to expand their laws to accommodating a full year, being able to pay rent for a full year. Mostly what the law provides is that what you pay monthly to make it easy. So in those instances, there are places also where they pay monthly in Nigeria, where you pay your landlord your monthly rent. What you are entitled to is a 1 month notice. Now, where you pay quarterly is 3 months. So you're also entitled to what? A 3 months notice. Now, all these that I've mentioned weekly, monthly, and quarterly. They are applicable under both the Recovery of Premises Act and Tenancy Law of Lagos. Same thing with yearly tenants. A yearly tenant, you pay yearly, you are entitled to 6 months notice to quit. However, there is now an inclusion under the Tenancy Law of Lagos. Now, which means that the Recovery of Premises has weekly tenants, monthly tenants, quarterly tenants, and yearly tenants. That is 4. However, under the Tenancy of Lagos, there are 5. There's an additional half-yearly tenant. That is a tenant that pays every 6 months. What the person is entitled to as well is 3 months notice to quit. Right? Any questions so far? Please just indicate whether there's question or there's no question. Either you just, say yes, just for me to say, say yes or say no, so you can move on. Okay, I will assume that there's no question since everyone is staying silent. Now, one important thing to note is that your length of notice to quit must not be less than the period stipulated. Right? Otherwise, it will be null and void. AP and Owoduni, African Petroleum Limited and Owoduni. And this is very important to note is that your notice to quit can be more than 6 months, but it cannot be less than 6 months. Right? That's the first point, which is to say that before your rent expires, you must issue a notice to quit, because the general rule is the notice to quit must expire at the eve of the anniversary of the rent renewal. Now, this is under the Recovery of Premises Law, which I would like to state that there's a bit of nuance to it under the Tenancy of Lagos. But now, general rule is your notice to quit must not be a day short. Meaning that if I'm meant to give 6 months notice to quit, your 6 months notice to quit must be 6 months. It must not be 5 months and 29 days. It must be exactly 6 months. So, and this is very important because for bad finance purposes, if you have to draft a notice to quit, law school can be funny and they will give you dates. Might give you the date of the expiration. They will give you the date of the expiration of the property. So it means that when you are calculating, by the time you want to date your notice, you must count backward. You must count backward of your date to make sure that you are giving the exact 6 days notice to quit. Say for instance, someone's rent is expiring December 31st. I want to issue a notice to quit. Your 6 months notice to quit must be from when? It must start from June. And now, that is one thing. Another rule, so it must start from June, right? July. Your notice to quit must start within from July. Now, on an additional note, when you are issuing your notice to quit, the month of service, it is assumed that notice to quit does not follow the general calendar, that it does not follow. So there's a difference between 1 month's calendar and there's a difference between a month and 1 month. I forgot now. I think they explained it more in ethics, 1 month and a month, 1 month calendar year, or I've forgotten how it is being put. But just know that for notice to quit, it doesn't start from the date that you serve. It starts within from the first of the month. So meaning that if I should issue you, today's 18th, if I should issue a notice to quit 18th of July, it doesn't mean that the notice to quit has started counting to say that 18th to 18th. Yeah, I think they call it 1 month, 1 calendar month. Yeah, the difference between 1 calendar month and, yeah. So it is not 18 to 18. It is going to start counting from what? 1st of August. That is how notices work. It is 1st to the end of the month. So it means that if you issue, so typically the month of issuance of notice to quit is always excluded from the calculation of the notice period. Say for instance, you have somebody whose rent is going to expire in December. If you are issuing the notice to quit in July, say today, July 18, it means that your notice to quit is not going to start counting from July 18. It's going to start counting from 1st of August. Now, if you don't do the calculation, you then have August, September, October, November, December. That is 5 months. It has automatically mean that what? Your notice to quit is invalid. So for you to issue a valid notice to quit for somebody that is meant to, to be evicted in December, it means that you have to issue the notice to quit in June. Because the month of issue is not always part of the calculative, it's not always part of the notice period, because it typically starts 1st to the end of every month. So it means that you should have issued the notice, but say the person's rent is going to expire in January, you issued the notice to quit from this month. You issued July, it means that it starts counting from August, September, October, November, December. And now, for a very good reason, your notice to quit can be longer than the general notice period, but must not be shorter, meaning that you can give somebody 7 months notice to quit, 8 months notice to quit. But the main important thing is what? Your notice to quit must expire under the cover of premises law. It must expire on the eve of the anniversary, meaning that if the person is meant to renew his rent 1st of January, the notice to quit must expire 31st of December. It cannot expire on the 1st of January per Recovery of Premises Act, Recovery of Premises Act and Recovery of Premises Law. So it must expire on the eve of the anniversary, and it must be the normal notice. However, under the Tenancy Law of Lagos, the provision makes it very, very, very funny, because when you interpret it, it makes it in a very way that it can expire after the anniversary, not necessarily on the eve of the anniversary, because the law, Recovery of Premises Act, specifically wrote it there as it must expire on the eve of the anniversary. However, under the Tenancy Law of Lagos, it puts that at the eve or thereafter. But then it must also be within, which means that, say for instance, you notice, like I did same example, the person's rent is meant to be renewed on the 1st of January, right? Typically, under the Recovery of Premises Law, the notice to quit must expire on the 31st of December. But under the Tenancy Law of Lagos, it can actually expire on that 1st of January. It can expire 2nd of January. But the basic is what? It must meet the required notice period of 6 months, 7 months. So most of what people do is just to give the extent, and people generally just to follow the general rule of expiring on the eve of anniversary, because of the interpretation of court and back and forth you might have in between it. And I think that is one basic thing that it is very important for you to note under recovery of premises. And yes, the other thing is, when you are done with your recovery of premises, after the notice period is up and the person refuses to quit, what do? You then go to court. You don't fight. No, before going to court, you serve the person another 7 days owner's intention to recover possession, to let the person know that your notice to quit has expired. You've refused to surrender possession. Therefore, you have 7 days to surrender possession. When the person does not surrender within 7 days, then you go to the relevant court to institute the action and file for it. And at the end of that, then you're instituting your trial and submitting all the documents. And when the judgment is in your favor, what the court will issue to the person is warrant of possession. You cannot, for whatever reason, say that you've given the person notice to quit, 7 days owner's intention to recover possession, and the person did not comply. You then go over and carry police and say, "Elaye, get out of my house. Your time is up." if the tenant should take the landlord to court, it's going to win fair and square, and that's it. There's no self-help in law. What happens is go through the due process. So what most landlord does is to avoid issue because of all these other things of, some tenants can be really stubborn. We know some tenants can be really stubborn and they will just want to, because some of them even have the idea that you cannot eject me properly, you have to go to court. And some would, and in that court process, you might be in 1 year, you might be in the house 1 year and you're still going back and forth in court. Especially for those that have high rental value, like the high court process, it takes long, right? It happens a lot. So, that's why it's very important that you make sure that you do everything by law. On the good side, what the law also helps to protect the landlord in these instances is, even if the matter is in courts, it doesn't stop the tenant from paying the rent. And also, even if you win the case and the person is meant to exit the house, there's what we call men's profit. The period that the tenant has stayed in the house, that this whole maybe court case is going back and forth, that is extended because you cannot eject the tenants in that instance, is not as men's profit, and the tenant is to repay the landlord in this instance, right? And that's what men's profit is. You must accrue. When it is accrued, you always have to recover it back. So I think that's like the major thing on the recovery of premises. I think that's all. If you have any question, please indicate, and if that's all, I think we'll call it a night.
So you said that one thing that they do to protect the landlord is that he has to pay back men's profit. The men's profit, is it apart from the rent that he's paying there?
Yes, it's apart from is separate from the rent. So say for instance your rent is 3 million, right, and your rent has expired, the landlord have given you notice to quit, you have refused to leave. You then use, let's say because of the back and forth in the matter, you use an extra or additional 6 months, right, after the expiration of your rent and expiration of the notice to quit. So it means that the person has stayed in the for 6 months. It would be like a pro rata thing, or like a how would I call it, like a prorated rate. It will be calculated as you've used 6 months in the house. You must pay for that 6 months that you've used in the house. You must pay, right? That is what men's profit is basically about. I don't know if that is clear, Stephanie.
Yes, thank you.
Okay, you're welcome. Any other question by anybody? Okay, if that's all, I think that's my cue to leave. I think there are other sessions this night, so you probably want to take a while to look at it before you join. And to be honest, I say it, you guys, don't worry. We all understand that bad finance can be a lot, but really, it can also actually be one of the easiest exams that you would write.